to Coffee Chat. I'm Becky Easton.
And I'm Ashley Moscarello.
And we are coming to you from Studio G with Goodman Law Group.
Hey, nice sweater.
You too. Isn't it August in Phoenix, though?
Yeah, but you know what they say, hot outside, frigid in the office.
And there is definitely no exception here. So, you've probably been hearing some of the recent rumblings about some case law that just came down out of the Ninth Circuit, basically saying that post-petition assessments can be discharged in a Chapter 13 bankruptcy, not just the pre-petition ones.
Whoa. Pre-petition what now? Let's back it up before we get into the facts and holding of this new case and cover some bankruptcy basics. I think the first thing to sort of explain is what we mean when we say pre-petition and post-petition amounts. So when an owner-debtor files for bankruptcy, they file what's called a petition with the bankruptcy court. And the pre-petition amounts are any debt that existed before that petition was filed. The post-petition amounts are any debt that accrues after that petition date. So there's kind of like this barrier of pre-petition and post-petition amounts. The other thing I think we should maybe touch base on is the types of bankruptcies. At issue in this new case is a Chapter 13 bankruptcy, but what does that mean? So I just want to briefly talk about the two most common types of bankruptcies that individuals can file. The first is a Chapter 7 bankruptcy, which you might have heard of. A Chapter 7 is referred to as a liquidation bankruptcy, and the goal in a Chapter 7 is to wipe out as much unsecured general debt as possible. So that would be things like credit card debt, maybe medical bills, things like that. Chapter 7 bankruptcy is designed for individuals with low to no income and little to no assets. So it's not always the perfect fit for all debtors. The other second most common type of bankruptcy that individuals file is a Chapter 13 bankruptcy. And that's often referred to as a reorganization bankruptcy, where the goal isn't to wipe out the debt, but it's usually to repay a portion or all of the debt that the debtor owes. So there's generally two scenarios in a Chapter 13 bankruptcy. Either the owner keeps all of their property and their assets and repays the debt to the different debtors, the different amounts that they owe, or they can surrender certain assets, like a car or pieces of property, and take that out of the bankruptcy estate, meaning the debtors with interest in those pieces of property or assets might not receive distributions from that plan.
So with that under our belts, let's jump into Goudelock, the 6001 Association of Apartment Owners. So this whole thing started when Ms. Goudelock quit paying her association assessments. The association then filed a foreclosure action to recover those unpaid assessments. So side note and shameless plug, so if you want to know a little bit more about foreclosure actions, we're actually going to be hosting a few seminars coming up here in October throughout the Valley, October 23rd, 24th, and 30th. So keep an eye out for one that's happening near you.
I would love to attend. Reach out to our office for more information.
Absolutely. So anyway, Ms. Goudelock moved out of her property, then filed for bankruptcy protection under Chapter 13. And as a part of her plan, she surrendered the property. So now since the property had been surrendered, the association's foreclosure action technically could have gone forward, allowing them to recover that, but the mortgage company actually stepped in, paid off that balance, and so then they could foreclose instead. However, they didn't actually do it for another 4 years.
So all that time, Ms. Goudelock was paying towards her bankruptcy plan, but not paying the ongoing assessments?
Right. So she wasn't living there, she had surrendered the property, and was expecting the mortgage company to foreclose, but they didn't for 4 years.
So someone's responsible for those amounts.
Yeah, the legal owner is still responsible for those under the declaration, but she was in the middle of a bankruptcy this whole time. And no one really took any action for those 4 years. Now, near the end of the bankruptcy plan, 6001 brought suit to determine whether those 4 years of assessments were going to, in fact, be discharged with that debt. So the court actually granted summary judgment saying that those assessments had not come due until after the petition, so they were post-petition debt, and she was going to be responsible for them. But they took it to appeal, and the appellate court actually reversed that grant of summary judgment, saying no, the assessment payments were actually an unmatured contingent debt that arose when she purchased the property, which makes it pre-petition debt, and then as a result, those 4 years could be discharged in her bankruptcy. So, I mean, that sounds a little alarming, right?
I, for one, am alarmed. Is there anything we can do?
Yeah, I think so. I mean, it's a cause for concern, definitely, but, I don't think it's the end of everything. I think there are two important things to note about this case. First of all, this was a Chapter 13 bankruptcy, and she actually completed her plan. So not everybody does that. Sometimes they don't complete it, and they don't receive a discharge, in which case you would obviously still be able to collect those unpaid assessments. Sometimes they don't complete the plan, but they do receive a discharge, and the Bankruptcy Code is actually pretty clear on that association assessments are not dischargeable in that instance. So here, specifically, she filed Chapter 13 and completed her whole plan. Then also, to note, she surrendered the property. So I think that if she had stayed in the property, the old adage of you stay, you pay would still apply. And I don't know that they'd be dischargeable in that scenario either.
Yeah, those are some really good points. I think, too, just generally for folks to keep in mind when you receive a notice that an owner in one of your associations has filed for bankruptcy, or if they're with our office and we receive that notice, one of our first steps is to file that proof of claim.
Yep.
Because that is how everyone involved in the bankruptcy knows what debts exist and who needs to get paid. So that is a very important step to keep in mind for all you managers out there that might be watching, to forward that over to us if you receive it, and we'll always let you know when we receive notice as well. And then the other thing that's always good to keep in mind in these bankruptcy cases is the motion to lift stay. And that's just basically asking the bankruptcy court to lift the stay that's in place because of the bankruptcy and allow the association to go ahead and collect on the assessments that are due and foreclose on those amounts
Right.
in order to collect them.
Yeah. So if you're not receiving those post-petition assessment payments, you don't want to sit around for 4 years like what happened here. You definitely want to take action to lift that stay.
That's right, and that's why we always say, don't delay.
Lift that stay.
So I think one other point that people should keep in mind is that they can also amend their proof of claim.
This is true.
And it's not set in stone. So if you have an owner like Ms. Goudelock who's in bankruptcy and who isn't paying her ongoing assessments, to try to get those amounts included as part of the plan, one option is to amend your proof of claim and say these amounts have also been accrued. That could also involve doing a sort of notice of post-petition assessments that have accrued so that the trustee is aware and the other parties in the bankruptcy know that this debtor may not be
Staying current.
Yeah,
right.
in the post-petition amounts as
Right.
well.
Exactly. So I don't think all hope is lost here. It just means that we need to be paying a little bit more attention and making sure that we're staying on top of things, don't you think?
Certainly, yes. And
That's what you need to know.